Hi, everyone. Thank you for joining us today. And our guest and presenter today is James Tumbridge. James is one of the authors of UK Data Protection Act 2018 that implemented the GDPR in the UK. He's also a lawyer with the tech specialist law firm Venner Shipley and regularly advises clients on global basis on the structure and approach to data collection and holding, as well as international data transfers and compliance issues. My name is Ivan Tsarynny, and I'll be the moderator today. And we have a really packed agenda, so we'll be going through it very quickly. We'll cover the basis, what is happening and why are we talking about GDPR and penalties and enforcements. We'll be also talking about recent examples and what we can learn from it. Also, some of the best practices, how to prepare from both legal, governance, and operational point of view. And because we received so many questions leading to the webinar, we'll try to answer as many as possible, and we have a dedicated Q&A session. And moving forward with that is actually why was GDPR and other regulations being put in place is that many companies have, or many industries actually implemented a lot of innovation-based projects and to digitize their business models, their go-to-market, HR, operations, and other lines of businesses and lines of operations. And as a result, they're processing a lot of data. That data often puts both organizations and subjects or people at risk if it's being misused or stolen. And as a result, there's multiple regulations that came into effect. For example, GDPR, also CCPA in California, and other jurisdictions such as Canada are really beefing up consequences of non-compliance and misuse of data. So as a result of transformation, what had happened is actually a real explosion of cloud-based third parties and tools. For example, the last 7 years, number of marketing tools increased from just over a couple of hundred to over 7,000. And an average enterprise today uses more than 120 marketing software as a service cloud-based tools. And actually, more surprisingly, more than 130 tools being used by HR departments. So there's a heavy reliance on third parties within organizations. So, and that creates that big tension where marketing or broadly business teams want to do implementing a lot of new projects, want to use new tools right off the shelf. However, it creates a tension and puts pressure on privacy, security, and governance teams where they need to ensure that what business does, they do it in the right way. And from both GDPR point of view and possibly other regulatory obligations. And because of GDPR coming into effect and a lot of organizations being affected by it, it's becoming a big imperative and a big priority to know that what is the right things to do to ensure that we're doing the right way. And one of the best ways is to learn from recent examples. And with that, I want to turn it over, James, to you. To take it over. I'm also transferring you control. Let me know if you have control.
I do, thank you.
Great, and over to you.
And from the UK, good evening to everyone, and good morning or afternoon, wherever you may be in the world. Thank you very much for joining us. I hope we'll run through some interesting information for you in this seminar. And I wanted to just lead off with some kind of big headline points about why we're all talking about data protection. Here's a stat for you that since 2013, we've had this massive number of data records lost or stolen. We've had 1.1 billion identities stolen in 2016, 2018, leading up to the GDPR coming in. And only 4% of these breaches were considered to be secure breaches where encryption had been used. And these are the kind of big picture issues that regulators and governments have been concerned about. And then you start to turn to the Permanent Institute's comment that $3.8 million on average is the cost of breaches. And in today's world, regardless of the nature of your business, the odds are you've got an online presence or a computer system operating, and consequently, the personal data issues will affect us all. So that's kind of just a big picture overview, big numbers, big concerns, big issues. There are many more stats I could have added. That brings us into the world of the General Data Protection Regulation. And what I'm going to try and do is run you through the big picture issues of what's been happening in the last 12 months, and then try and draw some lessons. And I think Ivan's going to make sure he picks me up on various aspects as we go through. So the first thing I just wanted to kind of pick up, I mean, I suppose you're all on this webinar, so perhaps you're in this bucket, but it was quite interesting at just the search trends on GDPR in the last year. At times we've even managed to outperform the Kardashians in interest levels on this strange little acronym, and we'll soon find out why it really matters. Because the most common types of complaints, we've already come up with 3 buckets: telemarketing, and of course, given anyone who's involved in sales, this is a major concern about the consequences, and I'm going to give you some examples as we go through of what we're seeing from regulators and some of the troubling positions that they're taking, I think, for those that are involved in marketing and business development. The next category is promotional emails, and they are very closely aligned. And the third principal bucket is video surveillance and CCTV. That has been catching all sorts of people, security companies, but a lot of government agencies. And I'll comment on a couple of those towards the end, because a lot of people aren't necessarily stopping and thinking about images of people, voice recordings of people, that these are also caught under the GDPR. It's not just classic text. So the complaints are rising. This shows you between May and of last year and January of this year that we got north of 90,000. They're coming in regularly. And I think that is obviously a correlation with the greater interest in this area and the regular news coverage, mainstream and otherwise. We're also seeing that the number of data breach notifications has gone up. Now that's for 2 issues, but primarily because one of the big departures from the GDPR was the 72-hour rule that requires self-reporting of breaches to a relevant regulator. And the real reason behind this was not because every single breach is intended to result in a fine or something horrible for your organization, but actually the regulators wanted to get better data, genuinely better data, because there's always been a lot of extrapolation and estimation as to how often companies are having breach issues. So on the back of the 72-hour rule, they're hoping to get some much clearer information about when it happens, why it happens, and in what circumstances, to inform the guidance that will come next. So we're only going to see this number go up, and I think we're going to see it go up for the next year or 2 until it plateaus. And what everyone has to remember is that if you fail to report, that's an automatic fine. So they won't know that you haven't reported, but if it comes out later and you didn't report in time, there is no defense. So what are these breach notifications all about? Forgive me for those who are not so interested in the United Kingdom. I do data protection advisory work on a global basis, predominantly Europe, but because I'm based in the United Kingdom, quite a lot of the regulatory information I have is from my local regulator. But what you're seeing here is a very sharp increase in notifications of these breaches. The United Kingdom is 3rd behind the Netherlands and Germany. Maybe that's a comment on the nature of our countries, and maybe it's actually because the UK is sitting fairly well, but we're seeing considerable activity, and we're only slowly beginning to see how the regulators are responding to these kinds of informations, in particular because some regulators have found themselves a little bit overwhelmed by the number of reports. And we're seeing a lot more cross-border issues. But one of the good things about the GDPR, because so many things are considered to be negative, is it installated for the first time the concept of the lead regulator. And we're going to look at this a little bit when we get to the Google decision and the French regulatory fine upon Google, that businesses now have an opportunity to structure themselves so that you have an influence on which regulator you have to deal with. Because prior to May of last year, if you had customers in a number of locations, perhaps in 3 or 4 countries across Europe, and you had a breach that impacted them all, you could end up dealing with 4 or 5 different regulators in 4 or 5 different languages, all about the same issue, and it could be a serious drain on your company, and each of them could then fine you. Under the GDPR, the idea is that one regulator takes the lead and the others accept their findings and outcomes, which allows you, as the company dealing with a regulator, to keep things under a more even and controlled basis, whereby you only have one regulator to deal with. So which regulator you deal with is a really important decision, and what you do about the way you operate your business will impact which one you have to respond to. The other big growth area is subject access requests, where individuals turn around to a company and say, I believe you have my data. Please tell me about what you've got. The GDPR gave a number of new rights, broader rights to people, and some companies have really started to get swamped by these requests. I'm actually seeing competitors encouraging groups of people to put in these requests to competing companies. And I'm also seeing companies that never really stop to think about what might happen if they got one, and they're really struggling to get on top of the amount of time, human time, it takes to go and check files and systems, because most organizations have a series of softwares, and you've got to look at all the different places in which you might keep the data. So unless you've got an integrated business system, you might find that it's actually very time consuming to look at what's in a Word document, an email system, an Excel system, a finance related system, and pull it all together. And so you really do need to think about this, because you might find that if you start to receive them, they take up a disproportionate amount of your time, and they are happening more regularly, in part because there's no longer any fee to be paid before somebody asks you for this information. And a failure to answer it properly or on time is another automatic fine. So let's have a look at what we can learn from the fines. You've probably heard the big scary numbers, 4% of worldwide turnover. That can be an enormous number. I'm going to break it down in a little more detail as I go through, but this is just a kind of a big starting point. There haven't been a huge number of fines yet. What we've had is a lot of discussion, a lot of reporting, but the regulator takes several months from most reports before they make a decision. And of course, breach notifications on the graphs I showed you earlier were really peaking in the autumn of last year. So we're only slowly beginning to see the fines now in 2019 that are under the GDPR system. But the trend is clear. There's going to be more of them. And there's been some very big ones already, such as the Google fine at 50 million. But there's been some others on social media networks, sports betting cafes, and so on. We've already seen nearly 56 million euros worth of fines in the first 9 months. So what are the fines? Well, one of the things that's often overlooked is the lower level and the upper level. The truth is we all need to prepare for worst case scenarios. And actually, the regulators across Europe have all given different guidance on what's low and what's upper. The Germans take quite a hard-nosed view. The British are much more flexible as to what may or may not consider to be a lower level or a higher level. But what I've given you here is a bit of a steer to do with the split that's meant to happen. But one of the things that we have to realize is that although we talk about the percentage, the arrangement is 10 million euros or 2% for a lower level breach and 20 million euros or 4% for a higher level. So you could be a business with a turnover of less than 5 million euros a year, and you could still be ordered to pay 10 or 20 million, which would basically cripple your business. And given that the previous maximum fines were only £500,000, this is a significant and serious shift. How are they being assessed? Well, the UK regulator has given more guidance than most, and they claim that when they're working out what the fine should be, they're looking for something that is effective, proportionate, and dissuasive. I have to sadly convey that so far in the regulatory defence work I've done, I think dissuasive is their big fixation, and I think a lot of the regulators, as we'll see when I go through the examples, are looking for the early precedents, and I'm afraid no one should want to be in the early wave, because they're finding their feet, they're not sure what they're going to do, and they're heavily influenced by what I call the court of public opinion. So anybody that's got profile and anybody that's doing anything that's in mainstream media seems to be getting more fines and higher fines, which really shouldn't be happening, but that does seem to be the trend. We're meant to be looking at the gravity and the duration, the number of people involved and the damage, and these will be useful. But until we start seeing some pushback and some appeals, we probably won't get absolute clarity on what the regulators are likely to do. So let's start with the Google fine. It's the biggest, 50 million euros. The thing that's most interesting about this, in my opinion, is not actually what the fine was for. I think Google kind of knew that their transparency, their consents and terms had grown up in an era where they didn't have to worry about this too much. If you used Google products, you just kind of had to accept their terms. And most businesses and most individuals simply had. And it was that lack of bargaining power that led the French regulators to slap the fine on them that they did. But the really, really worrying thing is Google's European HQ is Ireland, not France. What this case exposed was that even a company of the size, scale, and intelligence of Google had not, unfortunately, structured themselves in a manner where they could take advantage of this lead regulator position. It is absolutely essential, if you are setting up an establishment in Europe, that you don't just do what historically companies have done. They tend to set up in one of two places. There's some emotional, practical reason because it's where you choose to live, or perhaps if you're coming from North America, what the old country was, and so you feel comfortable returning to whichever place you've chosen to go to. And maybe then, more importantly, if you're taking professional advice, it'll be driven by tax structuring. That's why Luxembourg has tons of companies, but nobody there, because a lot of holding companies take advantage of their very helpful tax and corporate rules. Ireland has enjoyed a lot of tech companies because of low corporation tax and a system that's very similar to the English common law upon which many North American businesses like to work. But I think the new thing to think about is which regulator are you going to be subject to on issues like this? If you are dealing with personal data on any size or scale, you do not want to be in front of a regulator that has a habit of higher fines or takes the view of what I call the Napoleonic Code civil system of saying, if it's not written down that you can do it, it must be a breach and you must be fined. As opposed to the Anglo common law background, which you find in Malta, Cyprus, England, Ireland, Scotland, Wales, and so forth, that tends to say, actually, we don't take that view. We look at the broad requirements, we look at whether you've been reasonable, we look at whether or not you are behaving in an appropriate manner, and you can use those to push back on the size of the fines. And what Google showed was that you can really get hit and get hit pretty hard, even though 50 million isn't massive for them. For most companies, it's very significant.
James, I have a quick question. Based on this lesson, what would you recommend for organizations based outside of Europe on considering as a first or second priority when they're to consider for proper structure under GDPR?
The two things to think about, Ivan, are first of all, where do you choose to have your corporate HQ for regulatory and tax purposes? And make sure that you may not choose the best data regulatory regime, but you certainly don't want to inadvertently choose the worst by following something that looks like it's very attractive for corporate tax or other reasons, and you find yourself in front of a regulator that's very difficult to deal with. I think if you're taking professional advice, make sure you get beyond the tax advisors and the accountants, and you get some information about attitudes and approaches of regulators, because some regulators live on the fines. So if you deal with a Spanish regulator, regardless of whether you do anything that you could put up as a defense, you'll always get fined. That is their structure. You push the fine down by negotiation, but it's all plea bargaining. Do you want to be in that environment? For some people, that would be a very negative experience. And the second thing is the law of contract. If you are selling anything, licenses, services, or otherwise, what is the law of contract that you try and place those arrangements under? Because it is the corporate HQ and the law of contract that you can control that pushes you towards the regulator of your choice, and that should then flow on to the privacy policy statements that you put on your websites or elsewhere. Does that answer you?
Yep. Thank you, James. Yep.
Great. So I'm going to try and move on as quickly as I can through the finding examples. I wanted to start with the United Kingdom. There haven't been a huge number under the new law yet, but there have been quite a number coming through that are of a smaller scale. And for many startups and smaller businesses, you've got to realize it's not just the Googles of this world that the regulators are looking at. So one of the things that the UK government adopted, and I'm responsible for this as one of the authors of the legislation, I thought it was important, I hope you agree. I didn't want the United Kingdom to adopt the approach that most of Europe has gone for, which is that the regulators live on the fines. So we in the United Kingdom continue to have a registration fee. For the smallest organisations, that's only £35, and for the massive organisations, it's about £400 a year. Not big money. Most people pay about £40. It's like an insurance system. You register, you pay that fee, and then the UK regulator often doesn't fine you at all. It makes you subject to an order to change your behaviour, and it only fines for egregious behaviour. I happen to think that makes the United Kingdom more attractive because I find most business people would pay a small fee to know that when they deal with the regulator's not rubbing their hands and thinking, oh, you're a big company. If I fine you enough, that'll pay for the regulatory activity for the next 2 months. But the UK has already begun fining companies that do not pay those fees. And they are not massive, but they are thousands of pounds. So this is something to pay attention to, because if you're a startup, you don't want to start on a negative footing with any regulator or pay unnecessary fines. The other kind of fines I wanted to talk about are the fines that we've seen in 2018 that were very big by UK standards, but were from events that took place before GDPR started. And the regulator in the UK has said if it was under the new law, they really would have taken advantage of the new fining regime. The first is Equifax. Equifax had one of the biggest breaches that we've had in recent history. Very unfortunate. 15 million people's data were hacked in 2017. The UK therefore issued the maximum fine it could, because Equifax is a company that sells products with a very high level of security, because it's about credit checking and it's very important. And they basically said that they would have preferred to do this under the GDPR, to issue a bigger fine, and it would have gone into the percentage structure, and it probably would have been up around £100 million. So that's a really significant difference. Facebook and the scandal around Cambridge Analytica and the sharing and selling of personal data betwixt companies and Facebook's role in all of that. Again, on that one, the UK regulator is still pursuing Facebook and actually trying to come up with entirely new structures around personal data usage. And their fine would have been in the order of £1.25 billion. So quite scary numbers for most businesses. The UK has also given us a couple of examples of what's going to happen to people for selling customer data. Anyone who is involved in marketing and sales needs to be aware of this, and some other cases I will come to. Bounty is a well-known company in the United Kingdom that has a very loyal customer base amongst young parents. They specialize in products for children from newborns to the age of 5 or 6. And they build up really good data on those people that buy their products. And they had been selling and sharing that data with other companies, but without proper consents and controls. 14 million individuals hadn't given their consent. The UK regulator was unable to fine them under GDPR because of when these events occurred. They didn't go for the 500,000 because they said it wasn't in the magnitude of a Facebook, but they went for 400,000. But they did say it could have been 17 million under the new law. Hall and Hansley is another one. They had 3 million text messages sent out without consent. That actually was the interface between GDPR and the PECA regulation. PECA deals with texts and emails without consent. I'm finding an awful lot of activity by regulators. They start with a GDPR inquiry and switch to PECA because actually that consent issue is much harder in that other regulation. And again, on this one, the fine was 120,000. It probably would have been considerably higher. The ICO didn't give an indication of what the fine would have been, but you could probably expect it to be a magnitude of about times 10. Moving on, failure to minimise. Denmark gave us our first bit of information about what do the regulators think you're meant to do to honour the minimisation requirement. Now, this is the requirement that says that when we gather data, we often gather far more than we need. There's a lot of standard forms. People give names, address, maybe some banking information and so on when they buy a car or any other product. and maybe they give information because you do a survey on their age profile and so on. How much of it do you need long term? You're meant to minimize. Interestingly, in this scenario, the taxa company in Denmark did minimize, but the Denmark regulator still considered that although they'd got rid of some names and addresses, they retained telephone numbers for an extra 3 years, and they didn't have a proper basis for that. They couldn't justify it, and they were keeping it for far too long. And consequently, they fined them. They did it on a percentage basis, 2.8% of turnover, so it was oddly between the lower and the higher. The Germans have sort of said it's going to be 2 or 4%, but the Danes are demonstrating regulators can do a gradation. But nonetheless, if that had been 4% of your turnover, I think all of us would have thought that was a pretty horrific outcome when they thought they were doing the right thing, but the regulator disagreed.
And James, so what can we learn from this example? Let's think about companies that have a customer database in CRM or on mailing lists, and what should they do? What should they consider doing?
I think there's two things. You have to genuinely have a review process for data that you've got. And I advise most of my clients to do it on an annualized basis, because if you're an ongoing business, you're always gathering new information. And at some end of the relationship cycle, you've got people in your database that you no longer need. You know, they're no longer a customer, they've moved on, and you just don't really need it. But actually, historically speaking, most businesses think it's incredibly time consuming to keep a clean, up-to-date database. And so they often just get bigger and bigger and bigger. And this demonstrates the risk of that. So you have to have an effective system for review and removal or minimization of the data that you're holding. And what I can advise anyone for any time frame, because there's actually a lot of flexibility, but the point is, whatever you choose, whatever level of minimization, you've got to be able to justify it. And I think what the taxa people found was they had chosen a system that was not based in any logical structure. They just decided that after a certain period they'd get rid of names, another period addresses, and for some reason they kept the phone numbers for a bit longer, but they couldn't justify it. And so you've got to entrench regular review, and if you keep information, you've got to have a reason.
Okay, thank you.
Let me get on to Poland, and this is possibly the most troubling, worrying, absolutely, oh my God, decision I will be telling you about this evening. It rips up the rule book on an entire area of business activity, and God forbid other regulators follow the Polish, and this shows you one of the challenges of dealing with a regulator from a smaller jurisdiction that doesn't get the same level of activity and engagement as a bigger jurisdiction like the United Kingdom. What we found here was a marketing company that their entire business was that they went out into the world, they gathered publicly available information, they put it into charts and structures, and they sold it. So if you've ever encountered those people that offer to come in on a consultant basis or otherwise and generate business leads, they are probably doing some form of cold call, telemarketing, whatever it may be, and they're doing it from some form of list of potential customers. What this decision shows is that if you go and gather that information, this regulator and potentially others say that the interpretation of Article 14 is that once you've gathered and created your list, you have to actively contact everybody on it, tell them you've created a list, tell them how you're going to use it, and effectively ask them to consent to continue to do so. How many people, if beginning to receive these kind of requests, are going to bother to answer or give you that affirmative consent? And the problem for Bisnode was that they had 6 million people on the database. They didn't have electronic communication options for all of them. It was going to cost them 8 million euros to send out letters to everybody. And so in the end, they've basically shut down a big chunk of their business and dumped a ton of their data. And if this happens, the market of buying lists is probably dead. And I would already say, to be frank, obtaining any list that you don't have good warranty and indemnity structures on, that you don't have faith that it's a clean, consented list, is a very high risk for any business.
So it sounds like this particular enforcement, this penalty, can be interpreted as transformational to certain businesses and business models, like for marketing, for list building, and also for just general prospecting activities that companies could be doing or have been doing for many years.
Absolutely. I'm really genuinely worried about this decision. My only hope is that some other decisions will come forward of a similar nature in other jurisdictions that will interpret things differently, or that will have the opportunity to take this to court somewhere and relook at the wording of Article 14. I've given a lot of advice on this. I don't agree with the Polish interpretation. It's certainly not the implemented structure under the UK legislation. What this was meant to do was mean that if you receive unsolicited material and you say, hey, where'd you get my number from? Where'd you get my email from? They had to actually be able to give you an honest answer, and you had under Article 14 rights to know where this information came from, so that you can, little by little, stop the spammers. So it is meant to make it more difficult to use non-consented databases, but I think this has gone too far, and my worry is that a lot of businesses will be slow to react because they won't realise that this risk is out there, that hundreds of thousands of euros in fines could hit you for using an unclean list, and God forbid you have a reputation that the regulator thinks, you're a Facebook type outfit that I must make an example of, and you find you get a really, really big fine.
Thank you.
I wanted to touch on video surveillance, and actually there's a slide I haven't put up I also want to mention, which is that in the United Kingdom, the tax authorities experimented with a system whereby if you were willing to let the tax authorities record your voice, you could do an identification by speaking to an automated system by telephone, and therefore pay your taxes and ask questions about your taxes. But even there, where that's the heart of the UK government, they never stop to think about data protection. They're in trouble. They've had to shut the system down, and they've had to try and reconsent. And here in Austria, we had something similar, but it was not the audio files, it was the video files. Not a huge fine. It was a retail establishment for surveilling people. You see it wherever we go these days. There are cameras everywhere, security video cameras. The retailer, however, was monitoring a public area without any real explanation, no decent signage. So although it wasn't a big fine, it sets an interesting trend. How many restaurants, pizza parlors, redistribution centers or otherwise have security cameras, and they are pointed to look at the building or access points or whatever it may be? The security guys have set them up for a security reason. How many of them have stopped to think that actually somebody that was trying to break in, or just somebody that doesn't like being filmed, could actually make a complaint against you? Slightly troubling, perhaps. We don't yet know what will be the trend, but Austria has begun the process. Italy. This is an interesting one because of the risk of processors. Under the old law, I spent a lot of time designing contracts for clients that wanted to be a processor, not a controller, so that they didn't have primary liability. Under GDPR, really everybody is to some extent a controller and must take that risk. And in Italy, we had an example of the 5-Star Movement, which is a large political party. They had an arrangement with a web provider. That web provider had a data breach. Although there was a contract and a structure that said these websites don't belong to us, we just kind of helped set them up. The regulator took the view that that wasn't acceptable, and Russo were fined. More interesting, to add to that, this is an example of something in the court of public opinion. Because it related to political websites, it got attention. And in fact, the regulator inquired and issued this fine after seeing newspaper articles, not because anyone complained. And also unique, perhaps, to Italy, technically these things took place before GDPR came in, but they decided to fine under the GDPR. Italian regulation has that uniqueness. This is another example of why you might want to think about whether you want to be subject to the Italian regulators, or indeed try and make sure you're with someone who's more predictable. In Germany, this one is about the scale of hacking, 800,000 email addresses. In this particular circumstance, there's a good part and a bad part to the story. The Germans knew this had happened. They told their regulator. The regulator was very pleased about this, but they were concerned about the unencrypted data, the use of plain text, and people hadn't stopped to think about pseudonymization. I want to make sure everyone understands pseudonymization. It's a word that gets bandied around and not always understood. It means that the data appears anonymized. It means that you can't immediately connect the data with a live human being. But it also means that it's not completely anonymized, in that if you have the software, the algorithm, or whatever it may be, you can convert it back and still find out who's who. A lot of people actually pseudonymize when they think they're anonymizing, because to truly anonymize breaks the data chain. And for most businesses and most people, you never want to completely break it so that you can never work your way back to the human being that began the data inquiry. This shows that the German regulator takes that quite seriously, and it fined 20,000 euros. And it was only the immediate reporting and notification that meant that it was that low, because they said 800,000 emails meant that this would have been at the higher end into the percentage, or millions of euros potentially. But this is a good example. Get your policies in place, report on time, you can get your fines lower. So no one wants to pay a fine, but I'd certainly rather pay 20,000 than say €1 million. Portugal. This is one for those of you that might be interested in special categories of data. This is the first decision in relation to medical data. In this one, quite a significant fine, £400,000 fine on a hospital, because staff members were looking at and reading data and they didn't have a justification for doing so. They hadn't minimized, they didn't have the right principles and effective organizational measures, and as a result, again, this is another one where the regulator actually acted on a newspaper article, not because of a complaint, but it shows that regulators are flexing muscles. And we've also had some like this in the United Kingdom, but none technically under the GDPR. We've had examples of secretaries and receptionists working in medical facilities that get bored and start looking at patient information to pass their lunch hour. 2 of those have been exposed. Both have had quite significant fines, but under the old law. And if it happened under the new law, I would fear the size of the fine would be large, because they want to deter people that have access to, whether or not you're suffering from a major illness or whatever, having any of that looked at without proper reasons. So I wanted to try and pull some of this together, give you some guidance from these fines. There are so many, we've only got so long. I deliberately picked different examples, different countries. Big point, selling data is dangerous. Buying data is dangerous. If you don't have clear consented data, you are running a risk. And everything in data protection is a risk analysis. And with most of my clients, I say, look, I can make you completely safe, but there's a price to that. So let's be sensible. Let's be commercial. Let's do risk analysis. Risk analysis is at the heart of the impact assessment. So you need to make sure you've got consent. You need to know what's going on. Retention decisions. It's all well and good coming up with a policy that says I'm going to keep data for the following reasons for the following period. If you don't live and breathe it, you're going to get fined. If you can't audit it, you're going to get fined. If you haven't minimized in an acceptable or justifiable way, you're going to get fined. Biometric data is a big issue. I mentioned HMRC is the UK tax authority. They didn't have adequate consent, so the government had to fine itself. Pretty embarrassing. So do you have consent for special categories of data, medical, biometric, etc.? It is treated with greater severity. Good policies, prompt notification will reduce your fines. Don't forget, just because you got a contract that says you're the processor, you run these risks. Finally, get your security and anonymizing in order, because these are the only ways in the face of a regulator to say, hey, I did all that I could. I was reasonable. I was proportionate. This is just unfortunate. At least with the Anglo-Saxon regulators, that will put you at the bottom of the fining tree. So, I can see a few questions are coming in. Ivan, I'll leave it to you to decide when you pick any of these up, maybe towards the end. How to prepare. This one is considered to be this legal point of view because it's my recommendations. Ivan's going to give you some alternative and practical ones. But basically, policies and procedures. You know, the detail of this and how the tech works is a bit complicated, but the day-to-day management and living with it is straightforward. Think about it and don't just buy an off-the-shelf policy that is simply cheap and cheerful and forget about it. If you deal with personal data with any regularity, and I guess if you've joined this seminar, you probably do, you need one that makes sense for your business. It's got to be the right level of guidance and transparency. And make sure you've got some internal structures and policies about if you start getting lots of subject access requests, who's going to deal with them? Do you know how to deal with them? Because what you don't want to find is that you waste a lot of human time or spend a lot of money on people like me coming in and fixing it for you because you get swamped. And you definitely need to have annual audit training records because, again, if you have a complaint or an audit or a problem, that is how you demonstrate to most regulators that you have tried your very best. And if you've tried your very best, you should get 0 fines or the lower end of fines. If you don't have records, if you can't open the metaphorical book and say, here they are, the day the regulator knocks on your door, you get fined. The other thing that people forget, customer and supplier relationships. If you've got long-standing relationships and contracts and services that you're perfectly happy with, when was the last time you looked? Are you sharing customer data and processing information with third parties? If those contracts aren't up to date and you had a breach, you get fined. If data is leaving Europe, you have to be careful that you've got consent. I've put there the EU and the EEA to specifically call out something. A lot of people think this is an EU issue. It's not. The law has been adopted by the whole of Europe, the EEA area, which is more than the current 28 EU countries. And so basically everything west of the Ural Mountains uses this system. And anything that leaves the physical content of Europe needs to have adequate consent because basically European regulators are suspicious about a number of places around the world. And unless you're sending data to one that they've approved of, it's another automatic fine unless you've got consent from the data subject. Privacy impact assessments, words that don't always mean much, but quite frankly, it's a risk assessment about where you've got data and what you're doing. And then finally, just be prepared if the worst happens, who in your organization will take charge and deal with things.
Thank you. And from actually operational point of view, one of the biggest challenges we are hearing and we're seeing are actually doing what legal and governance obligations are requiring organizations. So as simple examples from revenue generation or HR point of view, what companies we're seeing are having troubles with is actually, first of all, just knowing what data they collect and knowing what data they're responsible for. And then, like James had mentioned, is actually governing and ensuring the proper cross-border data transfers are conducted in a proper way, ensuring proper documentation and audit trails of what has been done. As there is a bit of a sentiment that is emerging of data governance and being seen from a similar point of view as financial governance, from a point of view where banks often ask a lot of questions when they're seeing a large chunk of money or funds coming in with questionable sources. Same with data is potentially being scrutinized from the list building point of view, making, like James mentioned, making sure that the list is clean and there's proper legal basis for processing the data about the subjects, and basically ensuring not just GDPR compliance, but also often some of the privacy and security risks could put issues towards CCPA compliance, COPPA, PCI when taking payments and other types of regulations, and ensuring that it is done in the proper way. Now, moving forward, we do have a lot of questions that we had prepared to be answered, and also live questions coming in just right now. So what we're going to go through is first question to James is one of the most common questions, will I get fined? And let's go rapidly through it in under 30 seconds.
I'm going to be as rapid as I can. I think the quick answer is yes. And the reason is, if you're posing that question, it probably means that you don't feel comfortable that you've got all the things we've been talking about.
Yep. So from just your experience, how likely would it be for a company to get penalized or investigated?
The downside is that there's an awful lot of what I call court of public opinion attitudes by the regulators. If they think you're a sort of political party, a Facebook or Google, someone with a lot of profile, they're much more likely to fine you. I find that companies big and small that are not household names, that have the things I've talked about, policies, procedures, and it's clearly an accident, not being asleep at the wheel, don't get fined. But anyone who hasn't followed the procedures, haven't got the records, or has a big profile, yeah, you do seem to get fined.
Thank you. And have any of the fines been paid so far? That's a question from an audience.
Yes, they have.
And what happens if a company refuses to pay a fine?
There is a mechanism to refer them automatically for enforcement by the national courts. One of the issues then, I suppose, is whether or not people still ignore a court order. But of course, if you're subject to the UK regulator, because London is the world's banking centre, London is very effective at collecting the money, because they will switch their guns away from you towards the man or woman that you bank with.
Okay. So does it mean that you cannot really avoid paying fine?
I don't think you can. And actually, the extraterritoriality, I don't know whether there's any questions about this, is a major issue. This regulation has been very cleverly written to make it very global in its scope. It applies to anybody resident in Europe, whether they're a European citizen or not, anybody who's present in Europe. So you could be an American citizen who flies into London and flies out the next day to China. For the 24 hours that you're on the ground in the United Kingdom, you have all the rights under this regulation. So if your data's lost while you have your single night stay in a hotel, you have all the rights under this regulation to complain and to bring to heel through the regulator the hotel. Equally, if you're a non-European company offering services to Europeans that are resident here, you are obliged to comply. And again, the long arm of the law, largely through the international banking system, will come after you. And finally, if you are a European-based entity offering services to anybody outside of Europe, in China, Australia, or wherever, because your company's here, you're again obliged to follow these rules. So unless you never leave somewhere like China, you could probably find a way to borrow the rights here and ask a European regulator to act for you.
And there's one other question regarding, and the question is, any comments about Canadian regulators? So I will take this very quickly. A couple of updates on Canadian regulators under PIPEDA and the Office of the Privacy Commissioner. A couple of weeks ago, there was an announcement about a decision on Equifax after the PIPEDA, after OPC had concluded their PIPEDA-based investigation, and they found that Equifax broke consent obligations where Equifax Canada transferred records about Canadians to its parent company in the US, practically reversing its previous guidance 180 degrees, where now Canadian organizations require a clear and informed consent for transferring Canadians' information or data across the border outside of Canada. And so that is actually quite a significant announcement. I think there's a consultation going up until early June, and the further information will be released afterwards. And also what I have heard in various meetings and events is that OPC is actually working on towards beefing up PIPEDA, and especially the enforcement part of it. And
yeah.
Question.
Sorry, Ivan, can I throw in 3 quick comments on Canadian regulators? Because I used to be a Canadian lawyer and I have 2 on staff. 1, actually 4, a joke. I'd love you to take yours back because the UK commissioner is Canadian, and she's not always easy to work with. But the three that I've noticed, other than the one you've very rightly brought up, is that actually Canadian regulators are precluded from sharing information with their international counterparts, but they are actually sometimes breaching that. There's some interesting developments with the BC regulator that may come out. I also think that the fact that the Canadian and European authorities are in consultation at the moment will add to that consultation you're discussing about beefing up your law, because Canada has been declared unofficially as no longer an adequate jurisdiction to receive EU data, but there's a stay of execution because the Canadian government is updating. And I think those are really quite interesting developments about how Canadian regulators are and are not allowed to work with other regulators around the world, and how the consequences of the activity in Europe are now beginning to be seen as a consequence of, are having an impact on how they're planning to move forward. And so I think there's a lot of interesting developments in the next 12 months in Canada.
Great. And very quickly again, 30 seconds, from your experience, where do most of the risks lie or reside within the organizations?
I'm sorry, could you repeat the question?
Where do risks reside in organizations when it comes to GDPR?
Any part of the business that doesn't tend to think about regulation is often a risk, but most commonly I find it's the marketing department. The marketing department don't like being told they can't do things, and they don't always stop and recognize that if you've been running for a long time and you've got a database that you built up before these kind of regulations, there's a risk analysis to be done about whether or not you're going to be reaching out to people who might now say, well, when did I consent? And you simply can't tell them. And I think that that's quite a common problem for many organizations, is their sales arm aren't thinking about it in the same manner as the compliance parts of the business. And the main thing is actually just having clarity inside your organization about, if you are suspicious of a problem, maybe you lost your laptop on a train, or you think maybe there's a suspicious email, do your staff know who to contact so that it gets to the right part of the organization? Because with this 72-hour limit can go really fast. If you are working across multiple time zones and the issue happens on a Friday, and God forbid Monday is a national holiday somewhere, you suddenly find you miss the 72-hour deadline.
Yeah, that's actually a very interesting operational problem that comes under the breach notification obligations.
I'm afraid I've already represented clients that have missed the deadline, either because the decision maker was in a different country on a different time zone, or because there was a national holiday in one of the two countries involved and they just couldn't get two people to talk to each other in time.
That's an interesting coincidence where 72 hours is 3 days, and it's not 4 days, 3 to 4 day time frame, but you lose the time if it happens on a Friday and a Monday is a holiday. So it's a very interesting point of view at breach notification. So one more question from the audience, and it's a very interesting question. So I will read it like it was typed. So for companies that are routing data globally that could have EU residents or EU subjects data, such as IP addresses, potentially other personal data going across data centers across the world, would the data holders or processors that are outside of Europe be subject to GDPR?
Yes.
Okay, that was a short answer. Thank you. And as always,
I like to surprise people. They always think a lawyer will talk and talk and talk. Now and again, I've got to surprise you.
Yeah, thank you. It's not a legal advice. Everyone should consult with their own lawyers, but that was a very precise question. And with that in mind, let's go to the next. A very common question: can I cold email businesses in Europe with a highly targeted message or message on LinkedIn?
You absolutely can, but you're still subject to all the same rules about, can you justify how you got the contact information and why you used it. And if you can justify it, you can crack on. These regulations genuinely aren't meant to stop us using digital tools, but what they are meant to stop is people obtaining information without thought and using it without thought.
Thank you. And I think we have time for one more question. Is GDPR working, or is it too burdensome?
I think that's in the eye of the beholder. I know some organizations that hate it, and some that have found it very useful. And certainly I try and find upsides. There aren't always many, but I'll give you one.
Yeah.
And I know, Ivan, I've told you this as an example. I have a client that thought, oh God, why have I got to do this? And they were kind of annoyed that they had to have someone like me come and talk to them. But one of the things I discovered is that their CRM, their client relationship database, they were paying a rather large annual fee to a software company, which was based on the number of data points that it held. By using the retention policy and cleaning their database, which GDPR requires, they've actually saved money because they're no longer paying the big fee, because they've found a way at long last to get their people to clean up their internal records and have a more controlled and structured database. So it rather depends on the nature of your business. I'm afraid it's like any other regulation. Regulation can be a headache, or if you find a way to embrace it, you can find it as a way to drive forward a more successful business.
Thank you. And one last topic is, what is the best method or number one thing you would recommend anyone that should do effectively to reduce risks and penalties?
Get a policy that makes sense for your business. All too often, people just grab a policy from somewhere, lovingly rip it off, which is my shorthand for copyright infringement, or go to somebody that's just selling some sort of form of cheap, here's a privacy policy. If the policy doesn't make sense to how you actually act day to day, I like intuitive policies. If you've got an intuitive policy, you often don't need to look at, am I doing what the policy says? Because you've written it that it matches your business. And that's the key. That way you won't have anybody doing something that they think is normal and actually doing something that gets you into trouble.
Thank you. And one comment I might add from my point of view is actually the right policies and rules in place, follow them and do them and have a proof that they have been executed. So with that in mind, we do have a lot more questions. We will try to answer all of them in the follow-up that we will send after this, after the webinar in the next couple of days. And yes, you will also receive a recording of this webinar that you can view later. And also, thank you, James, for joining us, and thank you everyone for joining the webinar. And a little bit later on, you will have an update of the upcoming webinars on the data collection study. Thank you, everyone, and have a great day.
Yeah. Thank you. Thank you very much for letting me join you.